Some of the situations where the tribunal may order for winding up of company on just and equitable grounds are minority operation. When the company abuses its power to an extent that it oppresses the interest of minorities, such as minority shareholders, the tribunal may order for winding up of the company. Deadlock in management. Simple incompatibility between majority and minority group is not a sufficient ground for winding up. Tribunal orders for winding up when there is a complete deadlock in the management. The following case explains the fact. NEJ Tobacco Limited. W&R were the only two shareholders as well as the directors of a private company. Subsequently, some serious differences developed and they became hostile to each other. They stopped even talking to each other. It was held that there was complete deadlock in the management of the company, and so therefore it would be just and equitable to order for its winding up. Loss of substratum. When the object for which the company was formed fails or becomes substantially impossible to be carried out, it is said to have lost its substratum. A temporary difficulty which does not knock out the company objects and purposes may not be permitted to become a ground for liquidation. Some of the following case laws deal with the point. Steam Navigation Company. Steamship was formed mainly with the object of acquiring the business of a firm engaged in flying steamers. The business was acquired, but later on, due to serious differences between the two, 7 out of 9 steamers acquired were returned. A shareholder filed a petition to the tribunal for the compulsory winding up of the company on the ground of loss of substratum. The petition was rejected since the company could purchase more steamers and carry out its original objects. Next is Dunlop India Limited, Calcutta. The respondent was a tire manufacturing company. However, its two manufacturing facilities had not been functioning for a long period of time. Properties of value in excess of rupees 2,300 crore had been removed from company without meeting debts of its creditors or even offering unpaid wages and salaries to its workmen and other employees. In such circumstances, instant petition was filed seeking winding up of respondent company. It was not noted that no workman or employee of company had appeared to resist order of winding up. Further, company had been unable to show any prospects of it carrying on any business in near or distant future. Besides, conduct of management of respondent company in fraudulent selling of assets estimated at rupees 2,300 crore made it just and equitable for company to be wound up. Accordingly, the court allowed petition for winding up the company where plant and machinery have been sold off and the company was not carrying on any business other than earning interest. A petition for winding up on the ground. In Hasaram Mahatani versus official liquidator of Nilkam Limited 2003. When the debt recovery tribunal orders the sale of the properties of the company under RDBFI Act 1993, it will be presumed that the substratum of the company has gone unless the order is set aside by competent forum. In International Caterers Private Limited versus Manor Hotel Private Limited 2007, where a joint venture agreement between parties to construct and run a hotel falls aground due to unilateral action by one of the parties, and also the company promoted under the agreement failed to pay bona fide debt and accumulated huge losses, the Delhi High Court ordered winding up of the company as just and equitable. in Majestic Infracom Private Limited versus Etisalat Mauritius Limited 2014. The Bombay High Court held that inability of the company to carry on main business or undertake any other business in a commercially viable manner indicates that the company has lost its substratum and it is just and equitable to wind up the company. The telecom licenses allotted to the company were cancelled by a judgment of the Supreme Court. The petition for winding up was filed on the grounds that it was just and equitable to wind up company inter alia on ground that substratum of company had almost completely been eroded, that there was a deadlock in management of company and that there was a complete lack of uberemia fides between main shareholders of company. Next is voluntary winding up. Winding up of a company can also take place voluntarily when a company chooses to do so by surrendering and realizing its assets for the payment of debts. Voluntary winding up is winding up by the members or creditors of a company without interference by the tribunal. A company may be wound up voluntarily when the period fixed by the articles for the duration of the company has expired or an event upon which the company is to be wound up has happened and the company in general meeting has passed ordinary resolution. The company has for any cause, whatever, passed a special resolution to wind up voluntarily. The company may be wound up by special resolution even if it is a solvent company. No articles of the company can prevent the exercise of this statutory right. A voluntary winding up commences from the date of passing the resolution. Section 308. Types of voluntary winding up. A company may wind up its affairs voluntarily in any of the following two manners. There are two manners. So, first is members voluntary winding up. Second is creditors voluntary winding up. Now, the differences between members voluntary winding up and creditors voluntary winding up. So, the first is declaration of the solvency is a must in members voluntary winding up, whereas it is not necessary in creditors voluntary winding up. The liquidator is approved by the members in case of members voluntary winding up, whereas both members and creditors appoint liquidator in case of creditors voluntary winding up. In case of members voluntary winding up, it is the members who control the winding up and the editors and the creditors do not play any active role as the company is solvent. In the case of creditors voluntary winding up, it is the creditors who control the winding up as the company is considered to be insolvent. Declaration of solvency. According to Section 305 of the Companies Act 2013, when the company proposes for voluntary winding up, majority of the directors need to make a declaration of solvency within 5 weeks preceding the date of passing the resolution for winding up and it must be delivered to the registrar. Procedure for voluntary winding up. Let us now examine the procedure for voluntary winding up by both members and creditors. So next is the procedure for members voluntary winding up. So there are following procedure. There is the following procedure which is to be followed when the company is wound up voluntarily by its members. First is solvency must be declared as per the provisions of section 305 of the Companies Act. Next is general body meeting must be held for passing special resolution. Then third is the notice of such meeting, such resolution must be given within 14 days by an advertisement in the official gazette and local newspaper. The company needs to appoint a liquidator and fix his remuneration, after which the powers of the board of directors and managing director ceases. The liquidator shall exercise all powers of the board and do all such acts that are necessary for winding of the company. Next is procedure for creditors voluntary winding up. So when the company does not declare the solvency, then it is a case of voluntary winding up by the creditors. The following procedure is followed. The company shall hold a meeting of creditors immediately after the general meeting of the members to pass a resolution for winding up. Next, the directors are required to prepare a statement of affairs, list of creditors, and statement of their claim so that same may be presented during the creditors meeting. Next is a liquidator must be nominated by members and creditors at their respective meetings. During the creditors meetings, a committee of inspection may be appointed. Liquidator's remuneration may be fixed by the committee of inspection. Meeting of the creditors by the liquidator at the end of each year if the winding up continues for more than a year. So next is petition for winding up of the company. Section 272 of the Company Act 2013 provides the entities that are eligible to file the petition in court for the winding up of the company. These are as follows, that is company, creditors, contributories, registrar, person authorized by the central government in a case falling under the clause B of section 271, the central or state government. Petition. An application to the court for the winding up of a company is made by a petition. A petition for the winding up of a company may be presented subject to the provisions of this section in the following case. First is the petition made by the company. A company may itself present a petition to the court for winding up after it has passed a special resolution. A company does not often present a petition to have itself wound up by the court, as it can achieve this object more conveniently by passing a special resolution to wind up voluntarily. Next is petition by any creditor or creditors. A petition to the court for the of a company may be filed by any creditor or creditors. The term creditor is not limited to one to whom a debt is due at the date of petition and who can demand immediate payment. Every person having a pecuniary claim against the company, whether actual or contingent, is a creditor, and such a person is competent to file a petition for the winding up of the company. Third is petition by the contributory or contributories. A contributory means a person liable to contribute to the assets of the company on the event of its being wound up and includes the holder of shares which are fully paid up. He can present a petition for winding up a company even though he may be the holder or of fully paid up shares, or that the company may have no assets at all or may have no surplus assets left for distribution among the shareholders. After the satisfaction of the liabilities, the grounds are contributory can present a winding up petition if the membership is reduced below the statutory minimum, or he is an original allottee of shares, or he is held his shares for any 6 out of the previous 18 months. The shares have devolved on him through the death of a former holder. Next is petition by all or any of the prior parties, with whether together or separately. A petition for the winding up of a company under section 433 may be presented by all or any of the parties, namely the company, the creditors or the contributories specified in section 433 A, B and C, whether together or separately. Next is petition by the registrar. The registrar can present a petition for winding up a company on the following grounds only. That is, namely, if default is made by the company in delivering the statutory report to the registrar or in holding the statutory meeting. If the company does not commence its business within from its incorporation or suspends its business for a whole year, if the number of members is reduced in case of a public company below 7 and in the case of a private company below 2. If the company is unable to pay its debts, if the court is of a opinion that it is just and equitable that the company should be wound up. Next is petition by the central government. Under section 243, the central government may cause to be presented to the court by any person authorized by a person authorized by it in this behalf. A petition for the winding up of a company, where it appears from the report of inspectors appointed to investigate the affairs of the company under section 235. That is, first is the business of the company is being conducted with intent to defraud its creditors, members, or any other persons, or otherwise for a fraudulent or unlawful purpose, or in a manner oppressive of any of its members, or that the company was formed for any fraudulent or unlawful purpose, or persons concerned in the formation of the company or the management of its affairs have been guilty or fraud, misfeasance, or other misconduct towards the company or towards of any of its members. Next is commencement of winding up. Before the presentation of a petition for the winding up of a company by the court, a resolution has been passed by the company for voluntary winding up. The winding up shall be deemed to have commenced from the date of resolution. In all other cases, that is where the company has not previously passed a resolution for voluntary winding up, the winding up of the company by the court shall be deemed to commence at the time of the presentation of the petition for the winding up. When an order is made for winding up, it relates back to the date of the petition, of the date of presentation of the petition. If no order of for winding up is made and the winding up petition is dismissed, the date of the presentation of the winding up petition has no relevance. As such, until winding up order is made, company has to be comply with the requirements of the Companies Act 1956 as a required of a company not wound up. Next is compulsory winding up. Section 433 of the Companies Act 1956 deals with the situation under which a company can be compulsory wound up. If special resolution being passed which stated the company should wound up, tribunal. Second is in case of default made in sending the statutory report to the registrar or holding the statutory meeting. Company failed to begin its business within 1 year from its registration or postpone its affairs for entire year. If the numbers of the members are reduced to 7 in case of a public company and less than 2 in case of a private. So if the company is unable to pay its debts. If in the opinion of the court that it is being just and equitable, the company could be wound up. The court has power to wind up the company on ground of the just and equitable. Whether the peculiar conditions exist and it appears to the court, it is just and reasonable. Next is now the difference between compulsory and voluntary winding up. Compulsory winding up of a company is brought about by an order of the court, whereas voluntary winding up is brought about either by the members or by the creditors of the company without the intervention of the court. In case of compulsory winding up, the liquidator is appointed by the court, whereas in the case of voluntary winding up, the liquidator is appointed either by the members or by the members of the creditors and creditors or both. So next is procedure for winding up under new regulations, that is 2013. Companies Act 2013 and Insolvency and Bankruptcy Code 2016. One has to submit a declaration to Register of Companies stating that company will pay its dues and liquidation is not to defraud any person. Within 4 weeks of such declaration, special resolution has to be passed for approval of proposal of voluntary liquidation and appointment of liquidator. Within 5 days of such approval, public announcement in newspaper and website of company has to be made for inviting claims of stakeholders. Within 7 days of such approval, intimation should be given to ROC and board. Submission of preliminary report containing capital structure, estimates of assets and liabilities, proposed plan of action within 45 days to a corporate person. Verification of claims within 30 days and preparation of list of stakeholders within 45 days from the last date of receipt of claims. For receipt of money due to corporate persons, bank account needs to be opened in name of corporate person having words involuntary liquidation after its name. Sale of assets and recovery of due money. Uncalled capital is realized. The proceeds from realization to be distributed within 6 months from receipt of amount to the stakeholders. The final report by the liquidator has to be submitted to corporate person, ROC, the board and application to NCLT. The order of NCLT regarding this solution to be submitted within 14 days of receipt of order. Now, the summary of this unit is winding up is a process by means of which the affairs of a company are wound up in a manner to dissolve the company and put an end to the life of a company. In the process of winding up, the company's assets and properties are administered for the benefit of the members and creditors of the company as per Section 270 of the Companies Act 2013. The procedure for winding up of a company can be initiated either by the tribunal or voluntary. Dissolution, insolvency, and winding up are all different, but these terms are used interchangeably. With the passing of Insolvency and Bankruptcy Code 2016, a company can now be wound up under the Companies Act 2013 only by the tribunal. The company may, by special resolution, resolve that it can be wound up by the tribunal. The registrar or any other person authorized by the central government may make application to the tribunal for winding up. The tribunal may order for the winding up of a company if it thinks that there are just and equitable grounds for doing so when the object for which the company was formed fails or becomes substantially impossible to be carried out. It is said to have lost its substratum. Winding up of a company can also take place voluntarily when a company chooses to do so by surrendering and realizing its assets for the payment of debts. Voluntary winding up can be done in two ways, that is, voluntary winding up by a member or voluntary winding up by the creditors. Winding up the affairs of the company voluntarily under the supervision of members, whereby declaration of solvency is made by the board and the same has been filed by the registrar. Winding up of the affairs of the company when declaration of solvency is not made by the directors and the creditors of the company control and supervise the entire process. Section 272 of the Company Act 2013 provides the numbers of entity eligible to file the petition in court for the winding up of the company, such as company itself, creditors, contributories, registrar, person authorized by the central government. If the case filed under the Section 271C by the center or state government with the passing of Insolvency and Bankruptcy Code 2016, a company can now be wound up under the Companies Act 2013 only by the tribunal. So this was the Unit 13. Next, we'll go to Unit 14. I'll take 1 minute break. Okay. Now the unit 14, consequences of winding up of a company. These are the contents. The introduction. The life cycle of a company resolve around birth, incorporation and commencement, life and death. At each stage of its existence, the company is answerable to many stakeholders. The accountability of a company is greater at the time of its winding up. The consequences of winding up are discussed in this unit. Consequences of winding up. Winding up of a company has several consequences for various stakeholders involved, such as shareholders, creditors, employees of the company, and many others. Whatever may be the mode of winding up, the consequences are as follows. Consequences as to shareholders or members. In a company limited by shares, a shareholder is liable to pay the full amount up to the face value of the shares held by him. His liability continues even after the company goes into liquidation, but he is then described as a contributory. A contributory may be present or past. The liability of present and past contributories has already been discussed in this chapter. So, in a company limited by guarantee, members are liable to contribute up to the amount guaranteed by them. Consequences as to creditors. Consequences as to the creditors can be of various types. Where the company is solvent, Section 528, where a company is being wound up all debts payable on a contingency and all claims against the company, present or future, certain or contingent, a certain sounding only in damages, shall be admissible to prove against the company. A just estimate of the value of such debts or claims shall be made. Sorry. Where a solvent company is wound up all claims of creditors when proved are fully met. Where the company is insolvent, Section 529, where a company is insolvent and is wound up, the same rules shall prevail as in the case of insolvency with regard to debt provable, the valuation of annuities and future and contingent liabilities, and the respective rights of secured and unsecured creditors. The security of every secured creditor shall, however, be deemed to be subject to a pari passu charge in favor of the workman to the extent of the workman's portion therein. Where a secured creditor, instead of relinquishing his security and providing debt, opts to realize his security, the liquidator shall be entitled to present the workman and henceforth the worksman charge, enforce the workman charge. Any amount realized by the liquidator by day of enforcement of the worksman workman's charge shall be applied rately be for the discharge of workman's dues, and the debt due to secured creditor or the amount of the workman's portion in his security shall rank pari passu with the workman's dues for the purpose of Section 529A, which deals with overriding differential payments. All persons who is in any such case would be entitled to prove for and receive dividends out of the assets of the company may come in under the winding up and make such claims against the company as they are entitled to make. Secured and unsecured creditors. The creditors may be secured or unsecured. A secured creditor has three alternatives before him. He may rely on his security and ignore the liquidation. He may value his security and prove for the deficit. He may surrender his security and prove for the whole debt. If a secured creditor, instead of relinquishing his security and proving his debt, proceeds to realize his security, he shall be liable to pay his portion of the expenses incurred by the liquidator for preservation of the security before its realization by the secured creditor. Preferential payments. In a winding up, some unsecured debts are paid subject to the provisions of Section 529A in priority to other unsecured debts. These payments are known as preferential payments and are as follows. All revenues, taxes, cess, and rates due to the central government or a state government or to a local authority at the relevant date, the amount should have become due and payable within the 12 months preceding the relevant date. Relevant date means in the case of a compulsory winding up of a company, the date on which a provisional liquidator is appointed, or if he is not appointed, the date of the winding up order. In case the company had commenced to be wound up voluntarily before the date, relevant date means date of commencement of voluntary winding up. In the case of a voluntary winding up of a company, the date of the passing of the resolution for the winding up of the company. All the wages or salary of any employee in respect of services rendered to the company and due for a period not exceeding 4 months within the 12 months before winding up. The amount shall not, in case of any one claimant, exceed some such amount or sum as may be notified by the central government in the official gazette. All accrued holiday remuneration becoming payable to any employee on account of winding up. All amounts due in respect of contributions payable during the 12 months before the winding up order under the Employees State Insurance Act 1948. This, however, does not apply when the company is being wound up voluntarily for the purpose of reconstruction or amalgamation with another company. All amounts due in respect of any compensation or liability under the Workmen's Compensation Act 1923 in respect of death or disablement of any employee of the company. All sums due to the any employee from a provident fund, a pension fund, a gratuity fund, or a other fund to the welfare of the employees maintained by the company. The expenses of any investigation held in pursuance of Section 235 or 237, insofar as they are payable by the company, advances made by a third person to pay wages or salary to any employee, or in the case of his death, to any other person in his right on account of holiday remuneration, shall, in a winding up, have the same priority as the persons to whom these payments are made out of money advanced have priority. Consequences as to servants and officers. A winding up order shall be deemed to be a notice of discharge to the officers and employees of the company, except when the business of the company is continued. Such a discharge shall relieve them all of the obligations under their contract of service. A voluntary winding up shall also operate as a notice of discharge to the company's servants. Company consequences as to proceedings against the company. When a winding up order has been made or the official liquidator has been appointed as provisional liquidator, no suit or other legal proceeding against the company shall be commenced except by leave of the court. Similarly, if a suit is pending against the company at the date of the winding up order, it shall not be proceeded with against the company except by the leave of the court. In a voluntary winding up also, the court may restrain proceeding against the company if it thinks fit. Consequences as to cost. If assets are insufficient to satisfy liabilities, the court may order for payment of costs, charges, and expenses of the winding up of out of the assets of the company. The payment shall be made in such order of priority inter se as the court thinks just. Similarly, all costs, charges, and expenses properly incurred in a voluntary winding up, including the remuneration of the liquidator, shall be paid out of the assets of the company in priority to all other claims. The payment shall, however, be subject to the rights of the secured creditors. Other consequences are once the court makes an order for the winding up of the company, its consequences date back to the commencement of winding up. The other consequences of winding up of the by the court are uh, intimina- intimation of intimation to officer, liquidator, and registrar, section 444. Where the court makes an order for the winding up of a company, it shall forthwith cause intimation to be sent to the official liquidator and the registrar of the order of winding up. Copy of winding up order to be filed with the registrar, section 455(1)(a), and on the making of the winding up order, it shall be the duty of the petitioner and of the company to file with the registrar within 30 days a certified copy of the order. Order next is order for winding up deemed to be notice of discharge, section 455. The order for winding up shall be deemed to be notice of discharge to the officers and employees of the company, except when the business of the company is continued. Where a servant of the company is on a contract of service for a fixed term, and that the term has not expired on the date of the order of winding up of the company. The order operates as a wrongful discharge, and damages are allowed for a breach of contract of service, and the servant is free from his agreement not to compete with the company. Suits laid, section 446. When a winding up order has been made, no suit or other legal proceeding shall be commenced against the company except by leave of the court. Similarly, pending suits shall not be proceeded with except by leave of the court. Powers of the court, section 446, 2 and 3. The court which is winding up the company shall have jurisdiction and to entertain or dispose of any suit or proceeding by or against the company, any claim made or against the company, any application made under section 391 for companies with creditors and or members, any question of priorities or any other question whatsoever, whether of law or fact, which may relate to or arise in course of the winding up of the company. Next is effect of winding up order. Section 447. An order for winding up of a company shall operate in favor of all the creditors and all the contributories of the company as if it had been made on their joint petition. Next is official liquidator to be liquidator. Section 449. On a winding up order being made in respect of company, the official liquidator shall, by virtue of his office, become the liquidator of the company. I'm giving time to ask doubts and questions. If you have any queries about this, you can ask me. For any doubts and queries, you can mail me at my email ID.